This podcast is presented by Regions Bank. You're chasing your goals, and it's up to you how you want to get there. Let Regions Bank coach you with financial tips that fit your everyday grind. Visit regions.com/next-step to learn more. Regions, member FDIC.
Hello and welcome to the AP Top 25 College Football Podcast. I'm Ralph Russo, college football writer with the Associated Press. My guest this week is Tim Nevius, a former college athlete who became an NCAA investigator and is now a lawyer and advocate for student athletes' rights. We'll talk to Tim about three issues that are getting a lot of attention in college athletics these days. First, name, image, and likeness, and how colleges are going about trying to craft new rules that will allow athletes to profit from their fame. Second, sexual assault policies. The NCAA hopes to revise its current policy to be more proactive instead of simply covering education and prevention. It's a tricky area to step into from a legal standpoint. Lastly, transfer rules. College sports might be moving toward allowing all athletes a one-time transfer with no restrictions. Thanks for listening to the AP Top 25 College Football Podcast. You can find us on Westwood One Podcast, at Apple Podcasts, just about anywhere you get your podcast. Please subscribe, and if so inclined, give us a good review. It helps college football fans find us, and it helps us find more college football fans. And away we go. Joining me this week on the podcast, and this is a rare experience for me, actually, an in-studio guest, Tim Nevius. Now, Tim Nevius is a name that I have a feeling college sports fans might sort of recognize, but maybe it's not like a top of memory or top of mind. Tim Nevius is a former Dayton baseball player. He worked as an NCAA investigator after his time in school, became a lawyer, decided to go into work for the NCAA as an investigator. After about a year or so, a little more than that doing that, Tim?
5 years.
Oh, my gosh. Okay, 5 years doing that. Decided to take a different path, and now he represents athletes. He works on cases where NCAA rules are involved, and he is an advocate for athletes' rights. He has been a person working behind the scenes on some of the bills that we see right now, sort of the California bill with the NIL. So, and I think it's also fair to say that Tim is critical of the NCAA in a lot of ways. I wanted to bring him in to give some perspective on the three big issues, a few issues, but three big issues that are going on right now in the NCAA. Tim, thanks for joining me. Thanks for coming over.
Thanks for having me.
Let's start with issue number one, and we are recording this on Tuesday morning, late morning. Right now, Mark Emmert, Bob Bowlesby, the commissioner of the Big 12, and a few other folks are in front of a Senate panel testifying about name, image, and likeness and NCAA sports and where that might all be going. So that is news going on right now. We're not necessarily going to talk about what they're talking about because that is going on, but that is the biggest story in college sports right now. I'm going to throw very big picture topics at you, or a very big picture way of looking at this. First, what has been your involvement as far as the California bill, as far as sort of shaping the tone of this conversation about name, image, and likeness, where it could be going, and what kind of rights student athletes should have?
It's really been communication with the lawmakers and their staff to help, understand what direction they're taking with the proposals, why they're including specific language, what other pieces or issues need to be addressed, and then understanding how, there's certain pieces that can't always fit into every bill, that the law is not going to be perfect as we want it as athlete advocates. And so understanding how we can make it as best as possible while still getting it passed, because this is a significant push forward for the interest of college athletes. Right now, working with Ramogi Huma at the NCPA and on behalf of our organization, the College Athlete Advocacy Initiative, which is based here in New York City at the Urban Justice Center, just down the street from here, we're focused on a few different states right now, but including Florida, which I think has one of the best chances of moving forward, not just in getting this passed, but getting it passed fairly quickly and with an accelerated timeline, which means that it could take effect in allowing athletes to capitalize on their name, image, and likeness as soon as this year.
So the NCAA in October, the board voted to allow athletes to profit from their name, image, and likeness, but with no detail, right? It was a broad statement with no detail. So what does it actually mean? It didn't necessarily mean anything.
And just to correct you, they did not vote to allow athletes to profit off of their name, image, and likeness. What they did was they took a vote that essentially told all three divisions to meet and discuss potential changes to legislation that would not allow them to quote-unquote profit, but that would allow college athletes to potentially benefit from the use of their name, image, and likeness. And while at the same time talking about how they would never allow profit. Now, I'm not sure where they stand on that because the communication, the information that they've said publicly has been very confusing. It went from, as is always the case, in my opinion, with the NCAA, went from we could never do anything like this because it'll be the end of college sports as we know it, to, well, maybe we could do it, but it has to be consistent with this mysterious concept of amateurism, or what they call now the collegiate model, to now saying perhaps athletes could profit, but maybe only in limited ways. So it just keeps changing. I'm not sure where they stand on this. I don't even know if they know where they stand on this in terms of profit.
Right, and your corrections are perfect because I even when I say those things, I am cautious to again sort of emphasize that there are no details involved. And right now there is a legislative process going on within the NCAA. And listen, I have a certain empathy to a certain degree for the leaders of the NCAA because it is a massive organization layered in bureaucracy, trying to get a lot of disparate opinions and values, maybe not as much values, but priorities, and people on the same page who have lots of different approaches to an issue. So I understand that the devil is in the details, and working out details is a slow and laborious process, but I think it's important to point out what you did, and that is making grand statements and putting forth philosophical shifts is not the same as actually doing something. They've made marginal progress as far as actually working something out here in a practical sense. What they have done essentially is sort of made some grand statements which say we're going to now point the organization in this direction and get back to us in a year or so on what exactly that means. So let's talk about this from sort of a bigger picture standpoint. When I talk to you about the bureaucracy and things along those lines, I imagine that's probably one of the reasons why you are where you are, as far as going from someone who was within the organization to now someone who's outside the organization, in many ways pushing back against the NCAA. What brought you to this point?
You described me at the outset as a critic of the NCAA, which I accept. But what I would say is that my criticism is based on my experience and the knowledge that I've gained over my involvement in college sports, which dates back to my own experience as a Division I baseball player at the University of Dayton, to starting to study the issues a little bit more in law school, and then after law school joining the NCAA, where I worked for 5 years. But my opinions really started to change. I drew upon that experience as an investigator, particularly in the Ohio State tattoo case, in which we were, essentially punishing young men for selling their awards and memorabilia that they honestly believed that were theirs, and getting tattoos. And, this became a national scandal of totally disproportionate attention in my belief. To then joining Jeff Kessler at Winston & Strawn and helping initiate and lead what is now known as the Alston litigation, that really gave me the depth of knowledge to understand how exactly this association is operating. And then I also witnessed how they framed their arguments and how this became it's a PR battle in so many ways. The NCAA is nothing if not a multi-billion-dollar media machine, and they use that to their advantage in speaking to the public and shaping the way we think about college sports. And it's a result in part, my criticism is a result in part of not only recognizing what the facts are with respect to the amount of money flowing into this organization, where the priorities truly lie, as opposed to, focusing on the academic, educational, and emotional and life development of these young men and women, that at every turn when there's a conflict with that, their priority is money, making money, and exercising control over the athletes. But what I would say is that the justifications that they have offered at every turn, that's really what every day when I get up and I think about, why I believe in this cause, it's not just the unfairness, but it's how disingenuous some of these statements are that the NCAA makes. And let me just give you some historical context on this. We have, when Title IX was first introduced, the NCAA said this will bankrupt the entire system and bring the end of college sports as we know it. Obviously, that didn't happen, and now Title IX is a extraordinary success. They said the same thing when it came to the contracts, television contracts, in the Board of Regents case with University of Oklahoma and Georgia, challenged the restriction on the number of games that could be played on a Saturday afternoon or televised, that is. And obviously that ushered in the decision at the Supreme Court level that struck down the NCAA rule, changed college sports as we know it, and ushered in the modern era. They did the same thing, crying doom and gloom with respect to the stipends and cost of attendance. Obviously, that didn't change either. And they did the same thing with respect to capping assistant coaches' salaries. And they said if you don't allow us to cap coaches' salaries at the assistant level, it's going to bankrupt the system. So just for historical context, those are a number of things that have happened in the last 30 years that now they're doing the exact same thing again. And so it's my experience in seeing how just unfair things are, but also how the measures that they take to protect and preserve their profits and the status quo. And that bothers me at a very deep level.
To a certain degree, I feel like I need to, just from a journalistic standpoint, not necessarily push back on you, but sort of take a little bit of a devil's advocate stance. And again, I'll do this from a very 30,000-foot perspective. One of the things I feel like I see the issue, or maybe one of the underlying issues with the NCAA and college sports in general, is it is two different enterprises, right? Like, you played Division I baseball at Division I baseball, Dayton. I'm sure there are major league players that you played against and sort of passed through. Maybe not a ton of them, but I'm sure there was absolutely some of them. But nonetheless, even at the Division I baseball level, it is not what we see at the FBS football and Division I basketball level, especially high Division I basketball, where you really have these multi-billion-dollar minor league sports enterprises being jammed into a system that otherwise is meant for the Tim Neviuses who are playing Division I baseball, golfers, swimmers, track runners, places where you can find true amateurism. This is not necessarily to protect the NCAA or to make an excuse for them, but I always feel like that is the major conflict there, where you're trying to create a system that works well for so many athletes, where they're getting this scholarship. This is about the pinnacle of their sporting life, and they're getting opportunities that maybe they wouldn't have otherwise. Whereas this other thing, major college football and basketball, is a billion-dollar minor league sports industry. So I have a certain sympathy for the idea that they're trying to balance these two things and jam them into a system that works well for both. I just don't know if it's possible. Now, again, I don't necessarily expect you to have sympathy for that, but do you also see some of the conflicts that you see as part of that dynamic? This thing actually could work well for here, but once you slam all these billions of dollars into it, the wheels come off.
It's troubling. We have a multi-billion-dollar entertainment business that exists that is embedded in our higher education system. And the conflict is, as I see it, your points are well taken, not between the big high-revenue sports and the smaller non-revenue sports, but the conflict between prioritizing education and prioritizing profit. That's the big conflict. That has been the conflict at the center of this enterprise for 100 years now. But in the 1920s, when the Carnegie Foundation issued its report on the status of college sports, they discussed exactly this issue, that they were concerned about the commercialization and exploitation of the college athlete for the benefit and the profit of colleges and universities whose primary mission was designed to be and should be educating and developing young people. And so when you start to introduce profit-making opportunities into our higher education system, you create perverse incentives to pursue money and power and control over the education and development of our young people. And that's troubling. And that is, I would argue, at the core of every issue in college sports and at the NCAA.
Let me get back to name, image, and likeness for a second, because I had a feeling we might talk a little more broadly, which I wanted to do, but I want to get back to that issue. And right now, the NCAA convention, I was there a couple of weeks ago, and you can tell there seems to be at least an inch of progress in that they have come up with the idea of, okay, here are the three buckets we're trying to deal with here. There is some low-hanging fruit, which I believe they can relatively easily, and when I say they, the NCAA, make legal and say, here we're giving these to athletes. And that is things like an athlete has a side business that's not necessarily related to his sport or her sport, but they came in and they wrote a book. Maybe they're an aspiring children's writer. Maybe they give lessons in their sport on the side, and they'd like to be able to continue doing that, and they can maybe do that. So they call it work product, action centered around work product. And I think there's a lot of momentum to just simply, they've already been giving out waivers apparently on a lot of those areas. So I think there's some incentive to simply make that legal. And the two other areas that are a little more complicated come down to unregulated markets and regulated markets, places where it's very obvious what someone's name, image, and likeness is already valued. For example, they have services called, like a thing called Cameo, where an athlete can leave a message, or a famous person can leave a birthday message for a person and maybe make $50 a pop on that. Those areas are somewhat regulated. And then there's the sort of unregulated areas where, again, maybe a car dealership or somebody will come in and say, hey, I want you to sponsor me. Well, what is that value? It's hard to regulate what that market is, and I think that's the place that they're especially worried about. So I give that only as background to listeners. When you hear about those areas, what is your solution to this? What is your overall? And I feel like I can ask you that in a big way because I don't think it's overly detailed, but what is your solution to what markets the athletes should be allowed to walk into?
So I think what's interesting about this is that you ask the question as to what can we allow college athletes to do with their name, image, and likeness, and how do we regulate it? There is no other population, either on a college campus or in this country, that it faces the same type of scrutiny and restrictions. We're not asking what we should do with respect to the college coaches and their endorsement deals with Nike and Adidas and, other multi-million-dollar businesses. So why are we asking it of college athletes? And just the fact that, as you mentioned, this, quote-unquote work product or whatever it's being termed with respect to, music that the athletes create or artwork or, writing a book or, self-employment opportunities. Why are we restricting those in the first place, particularly because those actually provide great developmental and educational opportunities for young people in a very entrepreneurial economy in which we operate in? So, I would start with that first to say that we are restricting the rights of college athletes. And why? Why are we restricting the rights of college athletes? Let's ask that question first and note that no other student, including those students on college campus that aren't athletes that also receive financial aid or a scholarship, are unrestricted in their economic rights. It's very easy, I think, to say, yes, there needs to be rule changes to allow any athlete to capitalize on their name, image, and likeness with respect to all of those things that they have skills and talents in outside of sports. That's very easy to me. I think that with respect to self-employment and things like Donald De La Haye at University of Central Florida, who has 6 million followers on YouTube, should he be able to capitalize on that? Absolutely. There's no reason in my mind why he shouldn't be. And then with respect to actual endorsement deals, yeah, I think that your question is, how do you determine the value of the athlete with respect to that car dealership or otherwise? You let the market decide. I think you've anticipated that would be my response to that. What I would say is that people often think about these opportunities as, oh, you're going to sign a big deal with like Nike or an apparel company, or the car dealership. I think often comes up. Maybe because
cliche.
of like,
it's a total cliche.
I feel like it's because of like SMU football or something.
Right.
This is like embedded in what we think about when we think of like payments under the table to players, particularly football players. There are so many opportunities that we cannot conceptualize right now when we think about what people can do with their name, image, and likeness. Just like we couldn't conceive of, having a podcast through the internet 20, 25 years ago. There's so many things that people can do, and pointing to those things that are very obvious, sort of to take away from. It's also about like the Zion Williamsons and the top 2% or whatever. They're the only ones that are going to actually profit off of this. But I truly believe that this is going to benefit a whole host of athletes, allow them to capitalize on their economic opportunities as everyone else can, and especially women. And it'll provide new marketing and exposure for women, and hopefully elevate those sports to the point where they should be elevated. There needs to be more investment in women's sports. This is actually, in my opinion, an opportunity to do so, as opposed to the counterpoints of something, along the lines of this is any time they're going to implicate Title IX to try to say like, this is gonna be affected by Title IX, or Title IX will restrict these opportunities or reduce opportunities for women. I vehemently reject that.
So the main pushback that you will hear when you talk about a truly free market, and that's what the California bill essentially sets out, maybe with a little restriction around the idea of conflict of interest between an athlete can't have an endorsement deal that is in conflict with his school's or her school's endorsement deal. So if you're a Nike school, you can't have a personal Under Armour contract, which that seems at least, well, I don't know if it's fair, but at least it seems like it's a good way to manage things, right? Because those conflicts could be difficult. So as a first step, that seems like a fairly good idea to manage this situation. So, but the pushback you will hear from folks at the NCAA level is, of course, always about corruption. How do we, we are in a sport, we are an industry in which we recruit our players, which is, at its core means enticing them to come to our campus in some way, shape, or form. How does this not lead to abuse, where these opportunities are presented as part of an enticement package, and again, maybe the actual value of that name, image, and likeness is distorted because I just want to get this kid on my campus. So the corruption part of it, how do you respond to the idea that this is opening up all kinds of lines for corruption?
So I'll start again by rewinding to discuss the premise of that question, which is that we're framing this as incentivizing an athlete to attend a particular university and play for a particular team is seen as corruption, where in every other industry, whether it's in tech or media or law or, your organizations are attracting talent based on economic incentives and otherwise, and they do so without anyone thinking that it's corruption in most circumstances. So one, I would push back on the premise of that question, but two, the suggestion too, I think what people would say is that at the heart of this is some notion that some schools will gain an advantage over others, right? So it goes to the competitive balance question. The competitive balance question has been turned down by virtually every federal court in every NCAA case that has ever been brought, before a judge, because the fact is there is a lack of competitive balance as it exists right now. So to follow that logic, it would be that if you allow name, image, and likeness rights, you're going to have groups, you're going to have certain schools or individuals that root for certain schools or perhaps affiliated with certain schools, offering certain opportunities to athletes in order to incentivize them to come there, which would mean that Duke and Kentucky and North Carolina are going to get probably the top basketball players, right? It would also mean that Alabama and Clemson, Ohio State, and LSU, they're going to get some of the top football players. How would we operate in a world like that, So it just doesn't make sense that competitive balance argument has been debunked at every level. In fact, if you listen to sports economist Andy Schwartz, he talks about how the reserve clause back in the 60s in baseball, they basically talked about the same idea, but that economists since then have said that idea it doesn't actually protect competitive balance. That placing those restrictions on athletes, athlete pay, and athlete movement does not actually protect competitive balance at all.
Right. Essentially, the way to protect competitive balance is to have a professional sports league where everybody's agreeing to follow their own rules and have things like drafts and things along those lines. And we're not even sure if those are 100% legal, but the 30 teams that come together in Major League Baseball or the NFL agree to those things and have an agreement with their employees to agree to those things, right?
And the other thing I'll say about that is that we don't ask the same question with respect to coaches, right? We're paying millions of dollars to these coaches, and no one's saying, why is the coach at Duke getting paid $10 million and the coach at Dayton getting paid, much less? Is that a competitive balance issue? And if so, why aren't we regulating or restricting it?
Okay, so I want to take a very quick break here. I want to get back with Tim Nevius. He's an attorney, former NCAA investigator, now works as an advocate for student-athlete rights. I want to get into 2 other areas with him. Won't take him very long. I know he's got some other things to do, but we're going to be back on the AP Top 25 College Football Podcast right after this.
This podcast is presented by Regions Bank. You're chasing your goals, and it's up to you how you want to get there. Let Regions Bank coach you with financial tips that fit your everyday grind. Visit regions.com/next-step to learn more. Regions, member FDIC.
And we're back on the AP Top 25 College Football Podcast. Tim Nevius, an attorney, was once an NCAA investigator, played baseball at Dayton, is now an advocate for student-athlete rights, and has represented athletes in NCAA cases. Most recently, as far as the one that you might remember as a fan, you helped Chase Young through his issues with eligibility this past year at Ohio State. I want to hit 2 more areas with you. We won't take as long as the last couple. This week, the NCAA Board of Governors is going to try to, I think it's using the term, revise its sexual assault or sexual violence policy. The current policy is only one of education, and it's more guidelines than rules. So other critics might say they're not necessarily revising a policy. They're trying to actually come up with a policy. It sounds like the area that they might go toward is in some way regulating transfers who have on their records, be it police records or school records, a history of sexual violence. This seems to be an incredibly tricky area. And again, a place where I feel like I have a little sympathy for the NCAA because the laws from each state are so different. Do you think there is a way for the NCAA to, I'll use the term personal accountability, to ban athletes who have this on their record, to restrict athletes in some ways who have these offenses on their records? Do you think there's a viable way the NCAA could do that, considering laws change from state to state?
Yeah, I think that it has to be addressed, and it's quite frankly overdue. That we don't want individuals on college campuses that have been deemed responsible or convicted of sexual violence or violence of any kind. So if the regulation is to simply say that if you've been convicted or if you have been held responsible through a school administrative hearing for an act of sexual violence, then yes, I mean, I don't have any objection to that being, you can't play college sports. Now, the other question is in situations in which there isn't a conclusion, but there is an outstanding question as to whether or not this person was culpable for what they've been accused of. That's where it gets much trickier. But you have to rely upon the justice system or the campus administrative or disciplinary proceedings, which, quite frankly, need a lot of work, still need a lot of work. But I would say that I think you have to balance, a few things. You have to balance the recognition that over time we have not done a good enough job of listening to and responding to and believing, women in particular that have been sexually assaulted. You have to balance that with, making sure that the athletes are given a fair shake. But I would say that for anyone, here's what I would push back against is this idea that athletes are more inclined to commit acts of violence than other students on campus. I think that there was some suggestion of that recently, but there's not sufficient data to demonstrate that from what I've seen. So I don't know. I mean, there may be some information, but I would push back on over-categorizing that in a way that if you're a bad actor, you're a bad actor regardless if you're an athlete or otherwise, and you need to be held accountable, I believe.
Is it fair to restrict or ban, let's say you use the word ban, and someone from participating in college sports if they have already served their time? You know what whether it's administratively through a school system where maybe someone is found to be responsible for a Title IX violation, let's say as a freshman in college, right? They are suspended, that case is resolved. But then on the back end of that, should we no longer let that person play at all, or do people get second chances? Because I think that's where I have some conflict. There is I'm a little worried about just sort of shuffling people off into a bin of like, well, you're done here. You made your mistake, and now you're done. You cannot compete or be part of this space anymore.
Yeah, I have concerns about that too. I would say that the example that you brought up, I don't know how common that is, because if you are found culpable of committing an act of sexual violence, the chances of serving time within a 4-year or 5-year window, I think, may be.
Well, and I guess when I say serve time, I'm using that term very loosely. Not necessarily jail time,
exactly.
But let's say, again, serving a suspension, having some kind of discipline brought down upon you from a school level. Let's not even say the law was involved in this. From a school level, do you get another entry point after that?
Well, here's the issue with that is that I think that the disciplinary, most disciplinary consequences are expulsion at the school level.
Right.
And so the question then is, do you have enough information or evidence? Can you take it to, press charges or file a civil suit? And sometimes that happens, but oftentimes that doesn't. So if
can that player then go to another school?
Well, so that's the question.
That's the big
that
question.
they're grappling with.
I think that's the core of what they're trying to deal with now.
If you're expelled in the spring of 2020, and that's quote unquote serving your time, and you enroll in the fall or the summer of 2020 at another school, are you actually being punished, and have you learned anything? I will say, and I said this in the recent report about this, is that I do see this as another example of schools compromising their values in a way that is intended to basically pursue profit and wins over campus safety and security and actually addressing this in the right way. I don't think we can overlook someone's proven bad acts just because they're talented on the football field. That's a problem, I think. However, I totally understand and appreciate the idea. This is as a college athlete advocate and somebody who represents college athletes on a regular basis, that I think everyone deserves an opportunity at an education, whether that and graduation as well. Whether that also includes the ability to participate in college sports is another question. And is there something that needs to happen for those individuals that have gone through some disciplinary hearing, perhaps have not been punished adequately, but we still want to give an opportunity to, particularly for education, whether we can also invite them to continue participating in college sports. I think there has to be some restrictions, or at least a program in which athletes are held off the field. But that's a complicated question, because at the same time, you can't undo sexual violence, and their victims are always going to be there. So it's hard in that circumstance to talk about second chances. Mm-hmm. Although I do believe that everyone deserves an education, even if you've done something bad. We still need to help, rehabilitate and develop those people and educate them.
Okay, a less serious subject, but one that gets a lot of attention, and then we'll get you out of here, Tim. And that is transfer rules. In many ways, it's the same overall theme that keeps coming back. right? Where are your priorities? Why is an athlete treated differently than a student? But fans get very much into transfer rules because they affect competition on the field. And it creates a transaction wire that is similar to pro sports. But it also gives a lot of kids an opportunity to just, experience something different, get them in a better situation athletically, and a lot of times get them just in a better situation personally and education-wise too. It looks like we're moving to a point where everybody will have the same, operate under the same rules, and there'll be a one-time exception. I sense that we're heading in that direction. When we get there, who knows? When you look at the current situation with the waivers, and I know you've helped athletes on some of these waiver process, let's sort of stick there, because it seems like the waiver process was meant to be something of a compromise. Well, we're not going to give everybody the chance to be eligible immediately, but we'll reassess these waivers, and maybe through the waiver process we'll give some athletes more athletes a chance to be eligible immediately, and then that sort of went off the rails too. So where this stands right now with the rules and the waivers, is this a tenable situation? Do you think this is inevitably has to be blown up?
Absolutely, yes.
And why?
Well, so just to provide some historical context to this is that, there's been a lot of attention on transfers, the transfer portal, and waivers in the last 2 years, I guess, year and a half, 2 years. The rule was changed in October of 2018. It took effect in October of 2018, but it really didn't impact in the sport of football anyway, transfers that happened starting in January of 2019. So we're really only, a year plus into this new system. Prior to that rule change, and I think this is important, I emphasize this at every opportunity. Prior to that rule change, the rule was that you had to request a release from your current school first. And if that release was denied, that meant that you were not permitted to make contact with any other school or program for the purposes of being recruited there, or earn financial aid if you did in fact transfer to that school or any other school. That is just unfathomable that we were putting athletes, young people in that situation, that we were denying them the opportunity to earn financial aid, restricting their educational and their athletic opportunities, and giving power to the coaches that have incentives to restrict their movement because of their competitive interests. That was a serious problem that lasted way, way too long. That existed not just in football, basketball, baseball. That existed across the board. It still exists in Division II, and I've had clients that have been negatively affected by that. They just discussed it at the most recent convention and changing that rule, and I anticipate that will happen. Then when the transfer portal came along, that finally did away with those restrictions, thankfully. And prior to that, you didn't have the opportunity to actually seek a waiver if you never got the release in the first place. So it was really at least a two-step process. But now, since then, there's been a lot more attention on the transfer portal and the waivers. The waiver system has been adjusted most recently just last May or June.
Right. The idea of trying to provide a little more documentation, but also it sounded like they were codifying steps that were already involved in the process. Like, not only would we like to see this, but this is what you need to provide us. Exactly.
That increasing the sort of burden of proof almost in the quality of the information and evidence, which is challenging because, let's say, for instance, one of the ways in which you can get a transfer waiver, which essentially means that you can compete immediately upon transfer, you don't have to sit out the year, is to say that you were the victim of some egregious behavior by the coaches, teammates, or otherwise. And you have to document that. Well, let's say that most of the time it's going to be your word against theirs as the coach, and maybe something pretty serious happened, but you can't prove it. So demonstrating that can be very difficult. On another level, there are the waivers that relate to health, safety, and welfare. Those are situations in which your transfer is necessitated by, taking care of your own health and safety or welfare. It's important that you leave this school and go to another school for a variety of reasons. There's also family health issues, family financial situations, hardship issues like that requires the athlete to basically divulge all of their most sensitive and confidential personal, financial, medical, mental health, and other records to simply essentially beg for an exception to this rule to be able to compete when, again, no one else is required to do this, most notably the coaches who can skip from school to school making and chasing millions and millions of dollars. So I have a fundamental objection with how this system works, even though, it makes up a significant portion of my business as a representative for college athletes, that we're engaged in right now several different transfer waivers that we're, drafting and documenting and submitting to the NCAA. But I would much rather see this go away, because I don't think it's tenable, like you said, and it should be a one-time transfer for everyone.
Last thing, Tim, and it's a huge question, but maybe you can figure out a way to answer it in a concise way. Do you think that college sports is viable in its current? Can we still see college sports where there is big-time college football and big-time college basketball, while all these other sports sort of thrive on a different level and provide academic opportunities? In other words, will what we see of college sports, is this a viable enterprise going forward? Do you think that we will still see something like this 10 years from now?
I thought you had a big question for me. In the 1940s, the president of the University of Chicago took issue with how their intercollegiate athletic program was developing and raised questions related to their educational mission, 1940s, and essentially said, we are either going to be a football powerhouse. This is University of Chicago that was in fact a football powerhouse and was the founding member of the Big Ten, and for a long time was very successful in that space. Or we are going to be an institution of higher education, and we cannot be both. And they made a value decision at that point to pursue academics more than athletics, and they're now in Division III, I believe. And that sort of demonstrates the tension that existed in the 40s. And so you can imagine what the tension is that exists now. And this kind of goes to your earlier question related to, there are Division II and Division III and other non-revenue sports that sort of better encapsulate this notion of amateurism. And I wouldn't disagree with that. I do think that there are opportunities that exist in college sports that are much closer to this ideal of using athletics as a way to enhance your academic and educational experience. But we operate in a world in which there is a premium on winning games, making money, and even at lower levels, and even in some of these quote-unquote non-revenue sports have developed into revenue sports, such as softball. And you mentioned, we're talking about baseball. Yeah, I played at the University of Dayton. We were a smaller school. We were out there painting our own fences and all that stuff. I get it. But the College World Series is a huge enterprise, and there's a lot of money that's made there too. I'll note that in 2004, the revenues were somewhere around $4 billion made in college sports. That's Department of Education records. And in 2017, there were $14 billion. And in that same time, expenses have increased to the exact same level as revenue. And it kind of just shows you, the money that's being made, the money that's being spent, and where the values are, what the schools value. And I think that this is not answering your question, I don't think, at all. But I do think that I don't think that we can go back, that we can just simply erase what exists and go back to a purely educational, with these extracurricular activities kind of system. I do think that we can appropriately adjust the values within the current system while also affording fair and equal opportunities to men and women who participate in these enterprises and basically make up the workforce that drives this industry, the college athletes, and allow these sports to continue to exist in a way that the country loves and loves to follow, while also putting an appropriate focus on academics, but getting rid of some of these unrealistic and ridiculous notions and rules that are couched in this outdated and untenable notion of amateurism, at least at the highest levels, in my opinion.
Tim, that was great. I appreciate your time. Tim Nevius is an attorney, and he works in all different areas of college sports. I'm going to ask you to tell the folks what organizations you work directly with, just in case people are looking to find you.
Yeah, I appreciate that. So I'll first say the College Athlete Advocacy Initiative, which is a new nonprofit we started last year. You can visit 4collegeathletes.org to learn more about that organization. We're based here in New York at the Urban Justice Center, and it's devised to provide legal assistance to athletes that can't afford it, and also to advocate for change. The other one is, my own practice, which is just Nevius Legal, and that's, I'm the only firm in the country that's exclusively dedicated to representing college athletes on eligibility matters. And then I also do work with the National College Players Association and Ramogi Huma, who people that follow college sports policy know well. NCPAnow.org is that website.
Tim Nevius, thank you very much for joining the AP Top 25 College Football Podcast, and stay in touch, Tim.
Thank you,
it, man.
Thanks.
And now, 3 and out. First down. By the time you listen to this podcast, Michigan State might have a new head coach, but it won't be Luke Fickell, who decided to stay at Cincinnati. Yet another school and its fans are finding out coaching searches are really hard these days. Fickell to Michigan State is the type of situation that would have seemed like a slam dunk in years past, but Fickell is making more than $2 million per year at Cincinnati and brings back a team that will be favored to win the AAC next season, or at least among the favorites in the American. He can afford to be a little picky. More importantly, Michigan State is simply not an attractive place right now for coaches who already have stable gigs. Coaches want to feel good about who they're working for, the athletic director, and who their boss is working for, the president. They want a stable administration that gives them good support and a healthy environment, not just in the program, but throughout the athletic department and really throughout campus. It all affects the football program. And right now, as Michigan State digs out of various issues, it's a tough sell. Making matters worse is the timing. Maybe if this had happened in December, things would be different. But now a guy like Fickell also has to weigh basically screwing over Cincinnati and his team on top of the situation at Michigan State. The result, the Spartans are still searching, at least as of this recording. Second down. The great Bill Conley from ESPN, the man behind S&P Plus rankings and a recurring guest on this podcast, recently put out his returning production standings. I like to think of it as the first step in truly previewing next season. Returning production is a way to go deeper into what a team has coming back than just returning starters. Among the teams near the top of the charts are Northwestern, Georgia Tech, and Houston. All those teams were pretty bad last season, really disappointing, but the returning production suggests that all should take a significant step forward next year. 2 more notable teams that seem positioned to improve in 2020, USC and Virginia Tech. Third down. On the other end of the returning production spectrum, the notable teams that will be looking to replace lots of production are Utah, which is dead last in the FBS, LSU, no surprise there, and Michigan. Regression for Utah and LSU seems pretty obvious after last year, and my guess is both fans are bracing for a bit of a fallback this year. Michigan is the really tricky one. The Wolverines won only 9 games last year, and you might recall they still have not beaten Ohio State during Jim Harbaugh's tenure. Not sure how a season to retrench will be viewed in Ann Arbor, since the highs have still not been as high as many would have expected under Harbaugh. The Wolverines open at Washington, another team that ranks in the lower quarter of FBS in returning production. That's the show for today. I'd like to thank my producer, Warren Levinson, for making me sound good. You can find this podcast at Apple Podcasts and Westwood One Podcasts. Please subscribe so you do not miss an episode. I'm Ralph Russo, the college football writer with the Associated Press. Thanks for listening, and come back for more next week of the AP Top 25 College Football Podcast.
This podcast is presented by Regions Bank. You're chasing your goals, and it's up to you how you want to get there. Let Regions Bank coach you with financial tips that fit your everyday grind. Visit regions.com/next-step to learn more. Regions, member FDIC.